Okay, thank you very much, Pamela. And it's a great pleasure to, let me get this light right, to be invited to speak to the event today, especially it's Carers' Rights Day. And can I thank everybody at Enfield Carers Centre, and particularly can I thank Caroline, because she's the person that's dealt with all my absent-mindedness and got me to online today, so that's great. The idea is that I'm going to speak to a PowerPoint slide that's going to be available, and I think that's going to take about an hour and a half, something like that. I'm not quite sure, because normally when I speak there's lots of discussion and interjection as I go along, but the plan is that you'll have to listen to me. Hopefully it will be of interest, and then we'll have an extended period at the end from 12 onwards or 12:15 onwards for discussion. And the idea, I think, is that I will finish at about 1 o'clock, just before perhaps. Is that right, Pam? I've got the right? Good, good, good. Yeah, so please sort of store up questions so that we can have a longer session at the end. I've got some questions that have already been asked, and I'll deal with those first, but I'm hopeful that we'll then have plenty of time for any other questions that you may have. If I should explain quickly who I am, hopefully you can see that I'm the Professor of Law and Social Justice at the School of Law at Leeds University. My chair in law is funded by a disabled children's charity, Cerebra. And what I'm particularly interested in is the sort of common problems that carers encounter, carers of disabled children, but carers generally. And once the helpline for Cerebra identifies commonly occurring problems, then we undertake research at the School of Law with our students to identify, to sort of quantify that problem, and then to try and develop procedures to systemically solve those. And as we go through, I'll mention a few things. At the moment, we're looking at particular problems for parent carers to get assessed, and also problems of disabled children with autism in particular and ADHD in getting recognized as being disabled children. My background is I'm a solicitor, but I've been an academic for several decades, and I've been very, very involved with drafting legislation. So I helped Carers UK draft the original Carers Recognition and Services Act in '95, and I was the special advisor to the Houses of Parliament on the Care Act, and that's an act I'll be talking about as we go along. So what I'm going to do is I'm going to load up, with a bit of luck, the PowerPoint, and I'm going to ask somebody to tell me that, reassure me that you can actually see that. So that you should be just seeing one slide now, the Care Act 2014. Is that okay? Thanks, Pam. I can't see the chat functions as I go through this. I'm sort of flying blind, really. So if you have chats, comments to make or things like that, then colleagues at Enfield Carers are going to be picking those up and recording them, and hopefully we'll have time to deal with any comments and discussions after we've dealt with the pre-asked questions, if that's the right term. So the topics I'm going to look at today is I'm going to rake through these fairly quickly. I'm going to look at the rights of adult carers caring for another adult first. Then, and in doing that, I'm going to look also at the rights of the disabled adult, the elder adult, and then the carer. Look at the rights of parent carers, which were strengthened by the reforms, and young carers, which were particularly strengthened by the reforms. But in much of the country, I'm not seeing a lot of evidence that that's been translated into dramatic change. Hopefully in Enfield is an outlier and things are much better. I should at this stage say that I don't live in London. I live on the Welsh borders and I work at Leeds, so I don't know the local context. I'm then going to look at carers and COVID and some other commonly occurring problems. And then, as I've said, we'll have a slot for questions and discussion. Just before I go there, talk about resources. On my website, you should see, hopefully at the bottom of your screen, a link to the website. I try and put up commonly occurring resources to deal with commonly occurring problems. And I write fairly extensively, and I try to get as many of those books up free to access. So if you go to the resources page of my website, which hopefully you can see now, you'll see a list of items that you can scroll down, which talk about fairly common issues. You click on that and you'll get a page or two of advice and discussion. On the left-hand side, I do a lecture series. So there's we've put up quite a few lectures on most issues. At the moment, a lot of these are focusing on, well, the first two focus on disabled children, but there are ones on continuing healthcare, of which we've had some questions, and other stuff. If you go to publications, then as I say, I try and put up most of the publications free to access. That's not true of all of them, but if you scroll down there, you'll see that there's one called Carers and Their Rights, which is a 2018 version. And you could just click on that and you'll get the whole of the document. It's over 100 pages long, I think. And in some of the questions that I've been asked, pre-asked, I'm going to be saying, well, look, I'm sorry, I can't deal with that in detail, but it's chapter 8 or chapter 12 or whatever of that book. So that's a sort of resource that gives you the detail of your rights, to your legal rights as carers, to social care support in England. So if you click on that, then that is downloaded as a PDF. I've also do a book on disabled children and their rights, which with a colleague called Steve Broach. And if you look at the bottom left-hand corner of that publication, you'll see the logo of the Council for Disabled Children. They've paid the publishers to enable this to be online free. And that's over 600 pages long, I think. So you can just download it there. And it's got chapters on social care and healthcare and education and what the usual stuff. That's a new edition this year. We publish a toolkit with Cerebra, the charity that sponsors my chair-in-law. And that's commonly occurring problems that parents encounter and all disabled people encounter and carers of adults. And that's been very well received. I think it's been downloaded over 50, 60,000 times. So it's free to access, and you may find that helpful. And I may, in answering discussions, refer to that because it has a lot of precedent letters and sort of tricks, basically, to be heard. I publish a big, huge, horrible book on community care and the law, which isn't free of access. It's over 1,000 pages, but that's the book lawyers will have and the courts use. It's the sort of the book on social care law. And in a few of the questions, I've referred to that. One of the questioners that I've been asked to respond to has obviously got a copy of that book. So nobody should go out and buy it. It's very expensive, but there must be some people, and one of them has asked a question who's got a copy, and that's where the technical stuff is about some of these answers. So you need to have access. The library's bound to have copies and the university will have several. And this is the book I've just finished, which isn't free either, but it's, for a law book, only 20 quid. So I'd ask you to rush out and buy it. And that's very much looking at people who experience disadvantage. So it's not exclusively carers, but they are a big part of the story, because I have spent the last 20 years looking at carers' rights. And it's called clustered injustice because the people who have disadvantage of this kind, and I think very much about carers, don't have a single legal problem. So when we're advising and supporting them at Cerebra or in my life as a solicitor, we may solve a particular problem, but that doesn't return them to the sort of happy lives that we fictionally live in adverts. They have other problems, and as soon as one problem is solved, another one will come along and fill the vacant slot. That they live with legal difficulties, difficulties of dealing with health and social care and education and social security and housing and adaptations and all sorts of issues. And they have not only their challenges, because as we'll see, your health and your wealth is impacted adversely by caring, but they have often to deal with the difficulties of the person for whom they care. So they have clusters of injustice, and I analyze that and explain how the legal system is very poor at addressing those problems. The legal system's good at sorting out single problems, but it's not good at dealing with these multiple successional concurrent problems. And I look at that. And in the final chapter, I say that the single most important thing that our research concerning legal problems for people who experience disadvantage has shown us is the single most important thing in solving those problems is a small, local, user-led, independent support group. It's not lawyers with magic wands. It's not judges saying wonderful things. It's having support, and it's not just technical support. It's emotional support, support to enable you to carry on, to know that you've got somebody there that you can turn to. And so sort of Enfield Carers is a sort of classic example of the group that I think the state should really be pouring resources into and supporting. And I'm pleased to hear that Enfield London Borough Council is supporting the organisation, because it's small, local, independent, user-led organisations that are crucial in addressing these clusters of problems. So that's the sort of background. What I want to start off with is just some basic points, legal points. Now I'm sort of put my legal wig on, or whatever one does. When people come to the advice lines that I support, or me as a lawyer, really, I'm not so much interested in the law, I'm interested in the evidence. If the facts are good, if the facts are strong, then you don't really often have to rely too much on the law. Gandhi, before he became an Indian statesman, was a lawyer, a barrister in South Africa. And he said, if you look after the facts, the law will look after itself. So the key message is to get, is in a way to focus on evidence, to get the facts. So if you are a carer or a disabled person, I think you need to keep meticulous records of what was said by whom, when. And that's in the Accessing Public Services Toolkit. We give lots of details about how you can capture evidence in a fairly simple way. Because when you've got a problem, you'll be able to turn to your evidence, to your ring, your folder, and say, look, this was said on that date, and here's an email confirming that, and so on. But with evidence, there's also an issue of who has to prove what. Does the carer have to establish something, or does the social services authority have to have the evidence? And it's something I'll look at quite a lot as I go through this talk, but I'll give you some instances. So it's something we'll talk about at the very start, is that the legislation, the Care Act, has this very important presumption, and that is the adult, i.e. a disabled person or a carer, is best placed to judge what's in their well-being. So this is a bit like the mental capacity legislation, if for those of you who are familiar with it. The Mental Capacity Act says that all adults are assumed to have the capacity to make all decisions. So if anybody wants to say that you don't have the ability to make a decision, they've got to produce some evidence about you personally that shows that you don't have the mental capacity to make that particular decision. The same now applies with people who are in need of care and support. If a local authority wants to say, well, we don't accept your assessment of what you need, what will advance your well-being, the local authority has to produce the evidence to show that you, the carer, you, the disabled person, are wrong, rather than you having to show that the local authority's view is wrong. It's a subtle point, but it needs to be remembered. Section 6 of the Act says there's a presumption of well-being. Actually, it's not Section 6, sorry, that slide is wrong. It's Section 1, and I'm sorry that that's there. Section 1, I'll correct that before I send it on. There's a duty, and we'll be looking at that provision in a minute. If a council decides that you as a carer or you as a disabled person have needs, the council has got to produce a care plan, a document that you get a copy of, that says how the plan will meet your needs. If you don't think that the plan meets your needs, if you think you need more hours, say, of support a week, it's for the council to show that you don't, rather than you to show that you do, curiously. Having decided what your needs are, the council has got to produce evidence that those needs are met by the care plan. I don't know if this is an issue in Enfield, but every year the local authority is supposed to review a care plan. And many carers that I know and disabled people that I know are fearful of reviews because they think that it may lead to a cut in their support package. The law says that although you must be reviewed every year, there's no requirement that you be reassessed every year. A review is just to see if things are working well. So if things are working well, there's no need for a reassessment. If a local authority decides that it wants to reassess you, it wants to perhaps cut your package, it's got to produce evidence of why that review became a reassessment. What was the evidence that in the review that showed things weren't working well, that gave the local authority the option to then open the sort of toolbox and take out the magnifying glass and look in detail at the nuts and bolts of the care plan? And I think perhaps one of the most important things, and we'll look at some cases on this, is that if a local authority decides to reduce a care plan, if the local authority on a review decides that it's going to reduce the support that a disabled person is getting, and that will result in the carer having to take extra strain to make good the shortfall, then the local authority's got to prove, it's got to have written evidence, it's got to have in writing the fact that the carer is ready, able and willing to take that extra strain. Because as we'll be seeing as we go through, local authorities are not allowed to assume that carers are willing or able to provide care. So there's a small points, but legally they can be fairly crucial. It's not, in many cases, a situation of the disabled person or the carer having to produce evidence. It's the onus will be on the local authority to produce evidence. So looking through key provisions, definitions, and principles. The key acts, if you're an adult caring for another adult, then the act that you're dealing with will be the Care Act. That's not exclusively, but it's largely an act dealing with just adults. Of course, some adults are caring for other adults, like somebody caring for their grandparents, but they also may be caring for their children and their grandchildren. So you get sandwich carers. So they will fall under different acts. In relation to caring for their parents, they may well be covered by the Care Act. But if you are caring for disabled children or your grandchildren, then your rights will be covered by largely the Children Act. And in some respects, we'll see that they will always also be covered by the Care Act. So it's a bit of a mess, but by and large, if there's children involved, we look to the Children Act. And if there are no children involved, we look to the Care Act. Young carers are covered by the Children Act. And the key guidance for adults, it's a thing called the Statutory Guidance to the Care Act. It's available online. It's hundreds of pages long, and it's very good. I think by and large, it's very good. It's searchable. So use your Control F and put in a keyword and you'll find it. And by and large, it's a document that we as lawyers acting for families and disabled people will often cite, because it normally has material that is advances the rights of disabled people and carers. If you are, what I should have said there is that the key guidance for children, disabled children and parent carers and young carers is a thing called Working Together. It's the Department for Education, 2018. I should have put that there. And it's a truly dreadful document. And the current research we're doing at the moment is saying it's got to be replaced. And hopefully when I come to look at the situation of parent carers, I'll expand upon that. But we will be producing a report in the spring on our current research about the serious problems with this document called Working Together. And as I say, I hope to return to that in a short while when I'm talking about parent carers. Sorry, my thing is, oh, I see definitions, sorry, yeah. Definitions are important, but they shouldn't be an issue in most cases. The Care Act talks about an adult. It doesn't talk about a disabled person. I mean, the previous legislation, the National Assistance Act, talked about crippled people and handicapped, phrases, words that we'd never use today. They encapsulate the medical model of disability. So the idea with the new act, the Care Act, was that it wouldn't use language like that. So it talks about adults. Either it's talking about an adult carer or an adult in need, which is what I will often call a disabled person, but it could of course be a frail elderly person as well. And the criteria that establish eligibility say that that adult must have a physical or mental impairment or illness. Now that's a very wide definition, and that would include somebody with high functioning autism or a learning disability, or really any mental impairment or physical impairment or illness. It used to have to be permanent and substantial, but that's not there either. So the definition of an adult in need is very wide. A carer is someone who provides or intends to provide care. And the only criterion for that, criteria for that are that the person must not be paid to do that caring, and they mustn't be a formal volunteer with a voluntary organisation. Carer is widely defined, again, much more widely defined than the previous law, because under the previous law, the carer had to be providing regular and substantial care. And that no longer is an issue. And in this talk, I'll look at the question of what is care, because that's by no means clear. The Care Act has a set of principles which I think are important. The problem with these principles in section 1 is they're very long-winded and they cover just about everything. There's a duty in these principles on local authorities to promote the well-being of carers and adults in need. And as you can see, I mean, this is just one of 2 slides. The Act doesn't actually tell you what well-being is, but it gives you a hint by saying it relates to, and then it gives you a long list of pretty well everything to do with human life. And you can get a bit lost with that list. I'll look at it very briefly when we come to talk about eligibility. But it includes dignity and physical health and mental health and emotional well-being and on and on. The 2 I think that we need to sort of focus on, I mean, they're all important, but they're all fairly obvious in a way. But the 2 that I think we should focus on when we're looking at carers are the central 2. Control, that means really choice over how things are done. And I think the really important one for many people these days is to be able to have an ordinary life, the life lived by people that don't have to be involved in dependency work, to be caring for somebody who has needs, or to be a disabled person yourself. And most people will need to work these days just to pay household bills, because under this crazy economic system we've had for the last 40 years of neoliberalism, families have all had to go to work just to maintain household incomes. Many carers want to stay in college or go back to college, get a new skill. And so they need to take part in education. Many carers, when they cease caring, are going to have those skills in order to return to the workforce, because they will have lost huge pension contributions. They might want to undergo training, and many carers will need to have recreation, leisure, downtime. And the Act clearly states that that's a crucial aspect of well-being that must be promoted by local authorities. And we then get another page of not what it is, but what you have regard to. So another set of hints about the issues that are involved in well-being. And again, I think most of these are good practice professional points about listening to people, ensuring they participate in decisions about them, and so on. But it's the first one that I've already mentioned that I think is so important, is that the default position in any discussions is the individual, the carer or the adult knows best. And if the public body wants to say that's not the case, they will have to advance evidence to rebut that presumption. And it's incredibly important to emphasize and re-emphasize that carers don't have to care. Legally, they don't have to care. I've written extensively about this, and if you look at my website, there's a paper on it called "Does Your Carer Take Sugar?" But throughout the world, there are legal obligations on family members to care for other family members in the majority of states in the world. But that does not exist in the UK. To our credit, we abolished the liable family rule in 1948, the 5th of July 1948, when the National Assistance Act came in. There is no legal duty on families to provide care. You might say, well, isn't that wrong. Surely families should care. Well, of course families care, but using the law to force families to care must be wrong. And I would sort of say that vehemently. Why? Because if you believe that families should care, effectively you are discriminating against women. Because the reality is, caring is predominantly done by women. The heavy end of caring is overwhelmingly done by caring. And so if you're saying that families should provide care, you're basically saying women, mothers, daughters, wives, sisters are the people that should do that. We have to accept that caring is gendered. And therefore, as a state, where caring arises because somebody has is dependent for some of their needs, that falls to the state to address that, so that people who provide care are not disadvantaged any more than people who are disabled are disadvantaged, or people who are BAME are disadvantaged. So it's a crucial thing that we have to keep saying. Carers do not have to provide care. It would be highly discriminatory if we had legislation that said they had to. And even in those countries, in the more developed nations that do have liable family rules, like the United States, many of the US states have them, they're never enforced because of this particular problem. So councils, and the Care Act says this, must not assume that a carer is able and or willing to provide and continue to provide care. And we'll look at this. And it's a crucial obligation when they are assessing a carer to identify whether the carer works or wishes to work or remain in work, participate in education, training or recreation. And the care plan for the person that is cared for must then be adapted to enable the carer to continue with these activities. Crucially important things, and those are in the law. We live in a nation that is governed by the rule of law. Governments seem to have forgotten that recently, but we have to comply with the law. And the law says carers don't have to work, and we're not going to get any of this nonsense. We get a lot of that nonsense as carers, I think, where somebody says, well, for parent carers, parents have got to, it's your parental responsibility, and maybe in discussion, but it's clearly dealt with in the carers book. Parental responsibility does not mean you've got to care. It's a completely different concept to that. And we need to be clear that caring, the language of caring is not the language of coercion, an obligation. It's something that people do voluntarily. Some people do it very well, but some people aren't great carers. And forcing some people to be carers is not going to be in their or the cared for person's interests. So there's a duty under the Care Act, which I'm going to look at now, to assess need. This is an act where an adult is caring for another adult. And although we're going to look at the eligibility criteria, the technical stuff under the bonnet, effectively, of the Care Act, I think that in general, assessments are simply a question of what if. You just ask the question, what if? What if the social services department, in this case, the adult social services department, doesn't provide support, put its hand in its pocket and provide support? What will happen? And I think that's all there is to it. I think it's about evidence. We'll look, as I say, at this technical stuff in a minute, but it's just a question of what if. And the more serious the consequences are, the more difficult it will be for a local authority to say no. As I say, the greater the risk to a person's well-being, the greater the onus on the local authority to meet that need, or to give really compelling reasons why it's not necessary. And well-being, you know, as we've seen, covers a very broad spectrum. So if the facts are strong, rely on the facts. I've got a letter from the nurse, I've got a letter from my neighbor, I've got a letter from my daughter, I've got a letter from the priest, I've got a letter from the school, saying that this is what's going to happen. My doctor's saying that I'm on medication for the stress and my depression, my anxiety. That's a very serious impact on my physical and mental well-being. In order to address that, I need a break. Once you've got that, in the Accessing Public Services Toolkit, the document we have with Cerebra, we talk about this concept of credentialism. Curiously, if you want to produce evidence to a public body, and you just write a note saying, look, I'm under stress, I'm at risk, I'm this, and I can't cope, in many public bodies, it'll be almost ignored. But if you get your school headmistress or your priest or your solicitor or your GP to put it on his or her letterhead, then suddenly it's read and it's taken seriously. So if you say something, too often it's ignored, but if you can get it on somebody else's letterhead, and this is what we call credentialism, somehow miraculously it has more weight. So there are techniques, but you've got to get the evidence and say, these are the consequences if you don't provide this level of support for me and for the person for whom I care. Now, the legislation talks about assessments of adults in need, and it's very strong on carers, the Care Act. In a way, the Care Act was an act all about carers rather than disabled people. And what the Act says is that whenever you assess a person in need, you must involve the carer, full stop. You have to involve the carer. And of course, a carer doesn't have to be providing or regular and substantial care. So an individual may have several carers that have to be involved. Let's see. What we tend to, the phrase that is used is that assessments of disabled people should be carer blind. That means that the carer should be invisible when the disabled person is assessed. And that's because carers don't have to provide care. So what you need to know is what is the total 24/7 need that the disabled person needs. And once you've worked out what they need every day, every hour of the day, the local authorities, work that out. You then turn to the carer and do their carer's assessment. And during that carer's assessment, you say, are you ready, able and willing to provide some of this 24/7 care that we've identified? Because you don't have to. So you don't look at what the deficits are for the adults, you look at what the totality of their care needs are. And as the statutory guidance says at paragraph 615, local authority must consider all of the adult's needs, regardless of any support being provided by a carer. But information on the care that the carer provides can be captured during the assessment, but it mustn't influence the eligibility decision, because carers, hugely important, don't have to provide care. So we now look at the eligibility criteria for disabled people. I'm going to look at the eligibility criteria for carers in a minute, but the reality is, in the vast majority of cases, a carer's needs are met by giving services to the disabled person. So a disabled person, so a carer may need a break, just some downtime, or may need to, because they want to stay and work or go to college. And in order for them to have that break, that continue to work, there will need to be replacement support provided to the adult in need. So the adult in need has got to be assessed. And both the criteria for adults in need and for carers involve basically a 3-jump race. you've got to cross 3 hurdles in order to be eligible. Now, for adults in need, i.e. disabled people, elderly people, the first hurdle is that your need has got to arise out of your physical or mental impairment or illness, and we've already mentioned that. So the need has got to arise out of your impairment, your physical or mental impairment or illness. That's not often going to be difficult. We're going to see with people with autism, particularly young people with autism, that can be a problem with the local authority saying, well, we don't think that's an impairment, but it is, and so you'll have to use a bit of law if you encounter those sort of pushbacks. The second hurdle is the more difficult of the 3, and that is to show that as a result of that physical or mental impairment, you, the adult, can't do 2 or more important tasks. And we're going to look at that list of 9 tasks or 10 tasks. I always forget which it is. I think it's 10. So you can't do 2 or more things on a list. You're unable to achieve in the language that we use these days, sadly. And then finally, because you can't do this, it has a severe impact on your well-being. So well-being is, in a way, the lens that we look through when we're analysing eligibility. So we've got to have 2 or more outcomes we can't achieve, 2 or more tasks we can't do. It's got to have a significant impact. I don't think significant, there's much in that, but we'll look at a couple of cases which show quite clearly it's the local authority who has to prove it's not significant rather than the individual that it is significant. And the list of things you can't do is as follows: 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 outcomes. So they're basic things like feeding yourself, keeping clean, accessing the toilet, being clothed, and so on. And we'll look at a few of those just to illustrate the way the process is run. And as I've said, in order to be eligible, you must be unable to do one of those things. And unable to do doesn't mean simply you can't do it. It means that you can't do it without assistance, because we're ignoring any support. So if you could do it with assistance, legally you can't do it, because we're looking just at whether you yourself can do this. Or if you could do it, but it would cause you significant pain, distress, or anxiety, you can't do it. Or it would be a health and safety risk for yourself or others. Or it would take significantly longer than normally expected. So if you could dress yourself, but it would take half an hour or 3/4 of an hour, then you can't do it. Now, the regulations, which are really what we've just looked at, that list of 10 items, just lists various things. And the first one, oh, that's interesting. It seems to have gone quicker than I wanted to. Okay, so it lists things like, going back here, managing, maintaining nutrition, maintaining hygiene, managing toilet needs, and so on. And I've got PowerPoints lectures where I look at each of those in detail, but I'm skipping ahead now because we're looking at carers particularly. But the one we're going to look at is the one that says maintaining a habitable home. So if the adult in need can't do that, then it's an outcome that could, with another, make them eligible. The regulations simply list maintaining a habitable home, but the statutory guidance, which is legally enforceable, then amplifies that by saying whether the condition of the adult's home is sufficiently clean and maintained to be safe, a habitable home is safe, and so on. So this is an ombudsman's case. So this is a complainant who was receiving a personal budget, and it was paid to her as a direct payment to cover her eligible needs. The council reviewed her care plan and reassessed it and said, we're going to reduce your direct payments by 7 hours a week. But nothing had changed in her needs. But they decided to reduce how much support they provided her, 7 hours personal support a week, because they said, we're going to we no longer consider nutrition need and maintaining a habitable home need, because you get disability living allowance, and that's what disability allowance is for, to pay for your food and your home. Now that's complete nonsense. Disability allowance is not paid to clean your house, and disability living allowance is not paid to feed yourself. It's paid because you have continual bodily function needs. And how you spend your disability allowance is entirely up to you. It's not paid to you to subsidise this particular local authority. And the Ombudsman said what the Act says. He said, the Care Act places duties on councils to assess a need for care and support, decide what the person's eligible needs are, and that's 3-horse race, basically, a 3-jump race. Your needs result from a physical and mental impairment, you can't achieve 2 of 10 outcomes, and it has a significant impact. Where those eligible needs are identified, they must be met. There's nothing in the Care Act that allows a council to require a person to use their benefits this way. This person had identified need for housework. It has to be provided. Many local authorities say, well, we don't do housework anymore. We used to have a home help service, but we don't do it anymore. And they've just got to wake up to the fact that times have changed. The Care Act specifies it as an outcome that has to be met. This is the next outcome is making use of necessary facilities or services in the community. Can you get to your community facilities? And there have been a number of cases on this. This was a disabled person. He had a mobility car, so he was using his DLA to pay for a mobility car. He couldn't drive it, and so the council decided that his parents should drive it, taking him to and from his day centre. I mean, just pausing there, often people go to a day centre, or they will go for, as a form of respite care, effectively, so that the family can have a break. They'll go to an activity so that the carers can have a break. And then councils say, well, you've got to drive the disabled person to this facility, which is complete nonsense, because that's supposed to be downtime, your break time. And if you're driving somebody there and waiting or driving back, then that's taking away the idea of having a break. But anyway, the council were not saying that. They were saying this is a mobility car and the parents have got to drive it. Well, I'm sorry, but the law says you can't assume that carers are willing and able to provide or continue to provide care. They're not a taxi service. Yes, obviously they will use the mobility car to drive the disabled person around, but they can't be at beck and call 24/7. And the Ombudsman held that this was unlawful. The council had failed to consider the impact that it would have on the carers, on their health, their loss of respite care, and whether they were willing and able to do this. And there's been a series of cases on that, actually. Yeah. And the last outcome, and these are just an illustration of these 10 outcomes, is caring for a child. So this will be a disabled person who's caring for an adult. Yes, this will be a disabled person who's caring for an adult who's got caring responsibilities, but they're also caring for a child. No, sorry. This is, I'm just looking at disabled people at the moment. So this criteria, which is a criterion for disabled people, is where the disabled person's got needs like accessing the toilet, keeping the house clean, accessing the community or whatever. And they're also caring for a child. So this is a disabled person caring for a non-disabled disabled child. And of course, that is one of the outcomes that all adults will want to do. They will want to be good parents. So if because of your impairment, you're having difficulty fulfilling your role as a parent, then the state should provide support so that you're not treated adversely simply because of your impairment. So this was a, so the criterion says carrying out any caring responsibilities the disabled adult has for a child. And then it goes on to say local authorities should consider any parenting or other caring responsibilities the person has. The Ombudsman's case, I think, is an interesting case, fairly recent one, is a parent who's blind, and she wanted support from her personal assistant to enable her to take her children to school so she could meet, socialize with other parents. That's what you do with kids. You go and stand at the school gate and chat, and you see the kids, and you see, or you hear in her case, or you get to understand the other children and also to talk with their parents. It's a crucial activity of being a parent, I think. The council said that this wasn't social care need, which is, I think, nonsense, and that in any event, her husband could take the children. Parental responsibility, or another, which is an inappropriate phrase in this case. And the Ombudsman said that the mother's as responsible as her husband for taking children and is entitled to support to carry out her responsibilities as they have shared them between them. The council had failed in regard to the whole family approach advocated by the statutory guidance. So that gives you a sort of flavour, an indication of the way that the eligibility criteria work when we're talking about an adult having needs. A disabled adult, an older adult, a frail elderly person. We then have exactly the same process, not exactly, but a very similar process for assessing carers. And that's, again, a three-jump race. Now, there's now a duty to assess carers. There's always been a duty to assess, well, there's been a duty to assess carers' needs since 1996. But unlike the previous legislation, carers no longer need to show that they're providing regular and substantial care. Any care will qualify you for an assessment. You don't need to ask for an assessment. There's an automatic duty to assess if you appear to the local authority to be a carer. So if the local authority is assessing the disabled person, it must ask the question of whether there are carers, and then it must offer that assessment to the carer. And if the carer is eligible under the criteria we're going to look at, then the local authority must meet those needs. We've got a problem with hospital discharge issues, and there's a particular problem at the moment with COVID, and I'll look at this issue, that the hospital discharge guidance seems to have been amended. But the rule when we are not during the COVID emergency, and hopefully we won't be during that emergency soon, is that carers should be involved not only in the discharge, but they should be assessed. Their needs should be assessed before the discharge occurs. Now, that isn't happening anywhere, but that's what the Ombudsman says the law says. And I think that must be right. All too often, once the hospital knows there's a carer, it accelerates the discharge. Oh, there's a carer, and then you're discharged, without actually working out the severe impact that could have on the carer and the caring disabled person's relationship. And the Ombudsman has said that the carer's assessment should take place before the discharge happens. Now, as that is not happening, but that ought to be happening. I can understand why at the moment that is a slight problem, but of course now discharging people who may be infected with the virus really must take into account those sort of issues. I'll come back to that when I look at the COVID impacts on carers. What is care? I think that's quite a big issue. What is care? It's quite clear from the legislation that it's not just practical, it's also emotional support. And previous guidance said that many carers may be anxious and stressed. Many carers of people with mental health problems may be anxious and stressed, waiting for or actively seeking to prevent the next crisis. They may not be practically or physically caring at all, but basically highly stressed and anxious. And I think that caring for somebody with a mental health problem is some of the most difficult caring that can be done. It's intensely wearing because you are always walking on eggshells and tenterhooks trying to avoid the next crisis. So caring doesn't have to be physical or practical. And I think the one thing COVID has taught us, one of the many things that the COVID crisis has taught us, is how incredibly important it is to be visiting and supporting emotionally people in residential care, whether they're adults or young people. And I think that argument, is now no longer an argument. I think it's a fact that everybody accepts how incredibly important visiting somebody in a care setting is. So you're doing that because it's vital to the emotional well-being of the resident. So when you go to visit them, you're caring. So what? What do you want for help with that? Well, I'll come back to this in a minute, but well, these days, carers have to travel quite a long distance sometimes to visit a carer. And even in London, I imagine that it could be quite expensive traveling to and from visiting somebody in a care placement. And many carers are living on the breadline, and that's a huge impact on their well-being, just the cost of going to visit somebody. And the High Court has been told that the Department of Health agree, and we'll look at this case in a minute, that travel to and from seeing a carer is a carer's service that could be funded under the Care Act. And for many carers, that's no small issue. But I don't know of any authority that is paying, in general terms, for the cost of carers visiting people in care homes or other settings. And as we've said, the basic principles in carers assessment are whether the carer is willing or able to provide or continue to provide care. They don't have to do it. And whether they're able, which I'll come back to and say is perhaps the more important of those words. We need to look at the impact on their well-being, particularly work, education, training. And a care plan will be unlawful if it assumes that a level of input from a carer, because carers don't have to do it. So the assumption is that the carer is doing nothing, and anything they do will be gratefully received, but it's not under any obligation. You can combine the assessment of a disabled person and an adult, the disabled person and a carer, but only if they both agree. And if either disagree, they must be separate. Even if they're combined, they're done at the same time, there's got to be a separate statement for the carer's needs and a separate statement for the disabled person's needs, because you've got to separate them, even though they feed into each other inescapably. We've got to say, well, the carer needs to work, or the carer needs to stay in college, or the carer needs to have some, needs to go have activities. Go fishing, go down the pub, whatever. And there's a duty to provide, to involve any person that the care asks the authority to involve. So carers can have support whilst they're being assessed, and obviously that could be a carers organisation. And again, carers is a 3-jump race. We have to cross 3 hurdles to be assessed as eligible. And again, for carers, I don't think any of these hurdles are going to be difficult to cross. With disabled people, the first thing we have to establish is that our need is because we have an impairment. With carers, of course, they will need to establish their need is because of a caring responsibility, a caring role. Now, the legislation, these are the regulations, use a curious word. They use the word necessary before the word care. So your need arises not because you're providing care, but it's got to be necessary care. So what is that? Let's have a look at that in a minute. And because you have this caring role, you can't do, and there's a list of 9 outcomes, tasks that you can't do. And you don't have to produce 2 or more of those. Any of those things on that list, you will be eligible, provided the impact is significant. And I don't think much turns on significant, because I think, again, if the local authority says it's not significant, it would have to prove that it's not significant rather than the individual that it is. So it's any of the circumstances, but it's necessary care. What is that? Now, this is the list of outcomes, tasks that you can't do. And I want to look at those in a bit more detail than we did with disabled people. So the first of those tasks, out immediately under the red banner, outcomes. A, the carer's physical or mental health is or is at risk of deteriorating. Well, that's pretty well every carer. In a way, every carer would tick that outcome, because research, this is old research, more research, the figures are worse. But when I prepared this slide, 56% of carers were considered to have a caring-related health condition. Now it's considered a significantly higher proportion. But the test is not, have you got a caring-related health condition? Are you at risk of having a carers-related health condition? Well, 56% of carers have a caring-related health condition, stress, anxiety, depression, lifting injuries, and so on. 44%, the remainder, are at risk of that. So many carers will just pre-tick that box. And I mean, you will know these statistics as well as I do, but they're devastating. Caring at the moment, dependency work is, and dependency work includes paid care. It's gendered, it's overwhelmingly done by women, and it's overwhelmingly bad for your health because it is uncompensated in this country. So the first criteria is it liable to affect your health? And the answer is almost certainly tick that box. The second is, does the carer have any responsibilities for a child? So this is where I got mixed up last time. Whilst we're looking at carers, the Care Act is a carer, an adult carer caring for another adult. So in this situation, you've got an adult carer caring for another adult, but she or he would have children as well. And the statutory guidance actually gives an example of this, which I think is useful. So you have Divya, and she is caring for her father who's terminally ill. She lives with him, and she's providing a lot of unpaid care for him. But he gets a good direct payment package from the local authority as well. But Divya also has 4 children. So she's caring for her father informally, unpaid, but her father has a direct payment package in addition. But Divya's also got 4 children to look after. So she's a sandwich carer, caring for 2 generations. And she needs a break. And so the local authority decide to say that she should have a direct payment for herself so that she can have downtime, have a break. And she uses that for the children to attend a summer play scheme. So she pays for them to go off and go to a summer play scheme. So she can then be on her own. And as I always like to say, she then goes out clubbing. And that's probably the best thing that could happen to her. She just has a normal life. She can recover her identity and be the person she was. Now, that's interesting. That's the Department of Health drafting guidance saying this is good practice. I think it would be difficult. Many local authorities would say, well, if we're going to give you a direct payment, you're going to have to take the children to a library or to a museum or something worthy. But it's for her to have time on her own, to have a normal life with her mates. Providing care to other persons for whom the care provides. This is where you have a carer providing care for an adult and there's another adult who needs care. So I'm not going to look at that. Maintaining a habitable home, whether the carer's home is safe. And the evidence, again, this isn't terribly recent research evidence, but carers have difficulty paying for heating. They get into debt. They can't afford utility bills. They cut back on holidays and other activities. So the local authority's got to address that. They've got to recognize that's a real issue for huge percentage of the population. Is the carer feeding themselves properly? Again, let's face facts. Many carers are not. Are they able to maintain relationships? I think this is another of those boxes that are going to be almost pre-ticked because caring is very isolating. It does make many people lose touch with families and friends. And as we now know, loneliness and isolation is a major killer. As you can see at the bottom there, the research suggests that it can increase your chances of premature death by a quarter. And this is the biggie. Apart from health, I think it's work, education, training. Is your caring role impacting on your ability to undergo work, training, education, or volunteering? 54% of carers have got to give up work. There's about 10 million carers, I think the latest statistics are. Colleagues at Enfield carers will know better than I. 54% have had to give up work. Half of carers reduced their hours. 32% have been refused promotion because of their caring roles. Every year, 2.3 million people quit work to care. The impact on the British economy of carers giving up work is enormous. And that's recognised by the Treasury. The problem we have with carers is that the government recognises you've got to keep carers in work because it's hugely important to have a productive economy, and that requires people to work. And so it's economically hugely advantageous for the Treasury for as many people to work as possible. But unfortunately, the cost of keeping carers in work, of providing respite and other support, falls to local authorities. And the Treasury doesn't seem to think that it should pay them for doing that, which is a bit of a paradox. Facilities in the community, accessing facilities in the community. Over half of carers reduce the amount of the exercise they do. and engaging in recreational activities. So there we are. Now, what the Act says, and it's an issue which I think I return to a bit later, is carer-disabled persons conflict, is that it's not at all unusual for the interests of the carer and the interests of the disabled person to conflict. Stereotypically, just to put that in, you have the situation of the disabled person, an elderly person who won't accept any support except from her children. It won't have any strangers in the house. She doesn't need any support. They don't recognize the amount of work that the children, the daughters, are providing. And so refuses to have a care assistant come in, a cleaner or what have you. So what Section 20 of the Act says is that a local authority may meet a carer's needs for support in a way that involves the provision of care and support to the adult needing care. Curiously and importantly, even if the local authority is not required to meet the adult's needs, and I'll come back to that. So you've got a daughter living with her mother, say the daughter can't cope, she needs a break. The local authority propose that she has some help keeping the house tidy, doing the washing and things like that, and where she can go out and have some time downtime. But the mother refuses to have somebody in the house. She doesn't need looking after, she doesn't need support. Where a local authority is required by this section to meet some of the carer's needs for support, but doesn't prove feasible, because in this case, the mother or the husband or whatever is refusing, the local authority must, so far as feasible to do so, identify some other way. And what that's saying is that if there's a conflict between a carer and the carer needs a break, and in order to have to break, somebody's got to sit with the cared for, and the cared for is refusing that, the local authority can't just say, I'm sorry, they've refused, and close the file. The local authority has to keep the file open and worry away at it, find a way round those sort of difficulties. And there are ways around these sort of difficulties, but it takes time, and it deals with sort of conflict resolution, and I'll return to that as well. The other point that is important with that section is not only can local authorities not just say, well, I'm sorry, the person's refused, end of story, and walk away, but local authorities have got a duty to meet carers' needs even if the disabled person is not eligible for support. Now, that may not arise very often, but it can arise. So where would you have a situation where the disabled person isn't eligible because they can't, because they don't meet the criteria, because although they're a disabled person, let's say they don't have, there's not two or more things they can't achieve. They can, you know, they're not so impaired that there's two or more outcomes they can't achieve. So on the disabled person's assessment, they're not eligible. But the carer is eligible because they're caring and it would affect their health. Quite commonly that can occur because you have a carer caring for several people. Many carers aren't just caring for one person, they're caring for 3 or 4 people. And each of those individuals may have quite low level needs, but they need it and the carer is doing it. They may be meeting one of their care needs. But cumulatively, the impact on the carer takes them well into the long grass of eligibility. So in those situations, the local authority would have to meet the carer's needs, although there's no actual disabled person who would be eligible. But carers can also have services in their own name. So instead of being a sitting service for the disabled person, or a night sitting service, or a day centre for the disabled person, or some activity for the disabled person to give the carer a break, carers can have services just for them, and the guidance talks about relaxation classes, training, stress management, and so on. And as I've already said, that could include transport. And that's the case I referred to, the Hurley case in the High Court. Once there's an assessed need, the carer and the disabled person must have a detailed care plan, which spells out all the key conditions, who's providing the care, when, how they're doing it, why they're doing it, the qualifications of the carer, what happens if things go wrong, and so on. It's a bit like a detailed specification for a building plan. An important case, I think, we'll look at some of these now. This is an ombudsman's report where an adult with significant learning disabilities lived with his parents. Their care plan included 50 days of replacement care to enable the parents to have a break. They were elderly, and this person had very significant learning disabilities. 50 days may seem significant, but that's sort of the weekends, isn't it? Less than a week, a day off a week. And the cost of accommodating somebody with significant learning disabilities would be very expensive. So this is a cost-effective package. The council review this and reduce it down to 14 days. So they drastically cut that package. But nothing's changed. He hasn't got better. And the social worker doing the assessment says that she or he thought the sustainability of the parents maintaining their support was at risk. But the council said, well, we'll provide, if there's a crisis, we will step in and provide services. And the council said, look, the care plan, you've got to, in the care plan, explain why the evidence, the burden of the evidence lies on you to show how this person whose needs haven't changed no longer needs, these carers no longer need this support. The council needs to show what circumstances have changed to warrant the reduction in respite provision. In the Ombudsman's opinion, it wasn't acceptable for the council to say that it would offer emergency respite if the need arose. And I like this statement quite a lot. The parents' needs for weekends away are a little social life are not emergencies, but part of a planned, sustainable support regime. The council's assessment does not address these sustainability issues, and the guidance says that the impact on carers' daily lives and non-caring activities must be included. And the Ombudsman said that you must have contingency plans, plan B, when the inevitable breakdowns and failures occur. I'm going to need to lengthen my stride a bit to finish on time. I'm not sure if Enfield's got funding panels, but very often a social worker will say, I think you need a break. I think you need 50 days a year respite care. I don't think anything's changed. But then it goes to the panel, to a senior officers panel, and the panel reduces it. And that's what happened in this case before. The social worker says that sustainability is at risk, but that's in a way overruled by senior managers. Now, I'm not going to go into details in that, but funding panels are legally extremely dodgy. And very often the Ombudsman strike them down. As do the High Court. There's a Brighton case there, you'll see on these notes, and a Bromley case, lots of cases. And if you go to the toolkit, the Accessing Public Services toolkit from Cerebral, we've got a couple of pages on why panels are highly suspect legally. And just to sort of reiterate a point that I suppose is a thread that's run through, is that at law, once a need has been identified, it's got to be met. And so if it's 50 days a year, it's 50 days a year. And the council can say, well, we're short of money. Well, that's irrelevant. duties, the law has to be met. And so the statutory guidance says this very succinctly. It says a local authority's finances are relevant when it decides how to meet needs, but not whether to meet needs. So if a local authority has decided that you need a break, then it's got to provide the break. If there are two ways of doing it and one is less expensive, then it can choose the less expensive way, providing it genuinely does meet that need. So it has to meet the need, but it can take resources into account as to how it meets the need. And as I've already said at the very outset, the Ombudsman's made a number of reports on this. Authorities must not assume a carer is willing or able to provide care, including additional care arising from a reduction in the care package. It would be unlawful for a reduction to occur without assessing the carer and explicitly clarifying and recording whether she or he is willing and able to provide the additional care. And there's a few cases on that. Right, I'm going to move into young carers now. This will be quite brief and we can look at it in more detail in the discussion and questions that will follow. The young carers were a big winner under the reforms in 2014-15. The Care Act came into force, but also the Children and Families Act came into force in 2015. And that amended the Care Act to say explicitly young carers have a right to be assessed. Before, they were just dealt with as children in need, but now they have their own section under the Children Act, a major change. It's section 17ZA for some bizarre reason. Section 17 has been so amended that we've gone through the alphabet backwards again, so it's ZA. The duty to assess young carers is on the appearance of need. And as I often say when I'm talking to local authorities, most young carers are caring for adults. Only a third of them are caring for siblings, disabled brothers and sisters, and so on. So if you want to really implement your obligation to young carers, you should be spending time training the adult team to spot this and respond to this, rather than necessarily the children's team. Even though the regulations give gold-plated rights to young carers, in many areas this is not being fully implemented by local authorities. It was very good to hear that in Enfield you have a young carers project. And that is how I think it's one of those services that is best being at arm's length from the local authority, because of the shadow of safeguarding that always hangs over families in such situations. The Act, because the government has always, I'm not going to go really into it, but there's a sort of political issue with young carers is governments go out of their way to talk the talk on young carers, particularly if it involves a photo opportunity. Whether they actually walk the walk, I don't know. But when the government agreed to amend the legislation to include a specific right for young carers, I think they sort of went overboard, because there's now very detailed regulations about what an assessment should be done. It's incredibly meticulous, bureaucratic tick box. I think there's too much detail there. You can have far too much law, as I say in my book I've just finished. These are in the assessment regulations. There's been a recent case on young carers. Many of you may well know it. Have no idea why this came to court. I have no idea why Islington fought it, but the facts are that you had a child who was caring quite clearly for her mother, who was deaf. She had to translate it. The child could speak Trine language, so she translated for her mother, and and she also provided a significant amount of care for her younger siblings. Now, it's quite clear that the local authority thought that the mother was a poor parent as well as a disabled person. She considered that what she was asking her daughter to do was highly inappropriate. The local authority accepted that the young person had caring responsibilities beyond what was appropriate, but they argued that it was due to the mother being an inadequate parent. And so they refused to undertake a young carers assessment. I really can't get my head in brain around how local authorities get themselves into this sort of situation. So local authorities now are going to refuse to do a young carers assessment. So they're going to be judicially reviewed, because it's blindingly obvious at law, in my opinion, that they should do a young carers assessment. And even if they don't want to do a young carers assessment, why don't they just send a social worker out and do an assessment in an afternoon, costing, say, 500 quid's worth of local authority time? No, they're not going to do that. They're going to go on appointed principle, and they're now going to spend £20,000 losing a court case. I have no idea how local authorities make these bizarre decisions. So they refuse to do the assessment. And the judge says it's utterly illogical. Even if it is a parenting question, clearly the daughter's got caring needs. So perhaps I didn't need to tell you that, because you would have worked that one out yourself. But hopefully it's a salutary lesson for local authorities to just assess young carers when they come across them. I'm not going to go into the details of the regulations. I think that they're overly prescriptive. You're involved with your young projects. You can tell me if I'm wrong, and often am wrong. Parent carers is a big issue. This is the work we're doing at the moment, researching at Leeds University. And it's a real problem, because it's just not happening. It may be happening in Enfield, but throughout the country, getting a parent carers assessment is like drawing teeth. And the message doesn't seem to be getting down to the front line on parent carers. And we've just done a major survey of this issue, and we've got that. So the Children Act was amended also to put in a duty to assess parent carers. And again, parent carers shouldn't have to ask. They should be assessed as soon as the local authority knows that they exist. And a parent carer doesn't have to be providing additional support over and above due to the disability of their child. It's any parent who provides care for a disabled child has a right to parent carer assessment. The Welsh legislation is good because it mirrors this, but it also says that local authorities should assume that people who care for disabled children have responsibilities over and above which they as a family can cope, so that the presumption is that the state should be providing support for parent carers. And the assessment should look at well-being, the parent carer. And well-being is defined by the Care Act. Maybe this is the time to sort of pause and sort of stand on my soapbox and rant a bit. I am truly shocked by the way many parent carers are treated by local authorities. I'm really shocked. And we've got a number of accounts and a number of carers I know well. And it's a major problem. And the problem arises from the fact that many local authorities, the problem arises simply from that it was a mistake, I think, to put disabled children into the Care Act. I think they should have stayed in the National Assistance Act. Over 75% of all the children in need that are assessed by local authorities are children from families that are thought to be dysfunctional, children who are thought to be neglected or abused. Over 75% of the assessments are of that group of people. But the Children Act also defines disabled children as children in need. But they're utterly different from those children who are neglected or in dysfunctional households, as they're called. But routinely, when a disabled child is assessed, the social worker will want to interview the child alone, will want to interview the siblings alone, and routinely, in over 85% of local authorities, they will want to see the child's bedroom. Routinely, when parent carers are assessed, they are told they need to go on a parenting class. Even though there are no environmental or family factors, even though it's quite clear that the additional stress that arises is due to the child's impairment, they are treated as a parenting problem. Repeatedly, they have social workers turning up without notice because, and this is all being done, it seems to me, so that the local authority can pass an Ofsted inspection and show that all children's bedrooms are being inspected. These are deeply humiliating things for families that turn to the local authority for help and are then treated as the problem. The parent is the problem. And I may be putting that strongly, but I don't think so. The research we're doing at the moment is with the BBC, and the number of accounts that are utterly credible that this is happening is overwhelming. It's a serious violation of somebody's right to private and family life to walk in and insist on seeing the child's bedroom when there's no evidence whatsoever of a parenting defect, but that is routinely happening. So I think parent carers are getting a really bad deal in many parts of the country. I hope that it's not like that in Enfield. But it's a serious problem which we will be producing a report on next year, and there will be strategic litigation, and there probably will be an Equality and Human Rights Commission investigation into this, treating disabled children as neglected children and their parents. The law is good on this, and this is sort of, I'm not going to do much more on parent carers. I've got a bit more to do on COVID. But this is, I think, a case that really encapsulates what should happen. It's a sort of, if you had to talk about one case for parent carers, this is the case. So this is a single mother. She's got two children, one with significant disabilities and in constant need of supervision. And she approached the local authority for help because she was in work and she had to remain in work just to pay household bills to just survive. And the council told her that it expected parents to organise their work responsibilities around the needs of their children, that it wasn't the responsibility of the council to provide direct payments solely to enable parents to work. And that's said by many local authorities. We're not a babysitting service. It's your kid, it's your responsibility. Well, I'm sorry, that's just not right. The state is there to compensate parents of disabled children for the barriers that they encounter to living normal lives. You can't attribute those problems to being a parental problem. People don't. People have disabled children that they don't. It's not their fault. They shouldn't suffer for that. The state is there to respond in those sort of situations. So you've got it's a really old-fashioned response, because it is the responsibility of local authorities to keep parents in work. That's explicitly stated in the legislation. So one wonders whether the frontline social workers or their senior officers have had any training in the law since it changed. But the local authority said, but we are, we're soft-hearted, so we'll let you store up the respite breaks you have every other week. Every fortnight we give you a bit of respite. Instead of using it each fortnight, you could store it up and use it in the summer holidays. So she'll cease to have any respite during school period, but in the summer holidays, she can then use those accumulated days to give her some time to stay in work. And the Ombudsman said it's unlawful. And as he quite rightly said, the council has simply failed to understand the law. The child's assessment and the carer's assessment should feed into each other. The council knew her son needed constant supervision. It knew that the mother was in full-time work and her job meant that she couldn't pursue flexible working. And these were just facts. But neither the son's assessment nor the carer's assessment properly considered these issues. Government guidance clearly states that authorities should not assume a carer is happy to continue in their caring role. Council is required to consider whether she wishes to work. She does. Nothing in the assessment suggests the council properly considered the impact on her if she didn't receive support during the school holidays. And there have been a number of other Ombudsman's decisions to that effect. Just wrapping up, because I want to leave as long as I can for questions, but I've got a few more things to cover. I've been asked to look at COVID-19, and when I drafted this PowerPoint, well, let's say it was a while ago, I've forgotten, so this will remind me. There's a huge amount of guidance issued by the government concerning the current emergency. It all stems from an act passed in earlier this year called the Coronavirus Act 2000. It gives local authorities quite a lot of leeway to reduce their support. It gives them powers, but no local authority are using those powers at the moment. So local authorities in theory should be providing exactly the same service as they were before. But of course, the problem is not that they need to dilute their legal responsibilities, but they simply practically are not able to provide care, largely because of the social distancing rules. So we've got quite a lot of guidance, and it's that first one I think is really worth citing, and I'm going to quote it. It's in March, the Department of Health issued an ethical framework for adult social care, which I think is very good. I'm not normally terribly complimentary about the Department of Health, but I think that is a good document. And it talks about councils effectively doing what they can, using their best endeavours to meet need, notwithstanding that they've got to safeguard the health and safety of care workers and comply with social distancing rules. So councils have got to ensure that their decisions are rational, fair, practical, and have a reasonable chance of working. So that means there's going to be no rigid blanket, we will never do this, we won't do that. They've got to consider alternatives, alternative ways of thinking. Very conscious of device use from cultures and communities. And they've got to involve families, carers organizations in the planning of those steps. They've got to be inclusive. This can't be a diktat issued, and it's got to be flexible. And in the cases that I'm involved in, it's the word flexibility that I think is the really key thing that comes out of the guidance. Local authorities have got to demonstrate that they are being flexible, they're being imaginative, they're listening, because sometimes families are suggesting solutions which might just work. And the local authorities have got to consider that. And one of those issues, I think, just this is stuff you'll have with the PowerPoint, but it is just dwelling on, in a way, different domains of flexibility. And I think that being imaginative in the use of direct payments is one of the bigger issues we're seeing at the moment. So some local authorities are being very rigid in saying, well, you've got to use your direct payments this week, and if you don't use it this week, you can't carry it over and do it twice as much next week, or you've got to spend it within 2 weeks, not a month. Families are having huge pressure at the moment. They're without any support. Many families have been without support for 6-8 months. They're going to need to have one blowout break, one holiday, something at the end of that period. And they should be able to use their direct payments flexibly, carried over week to week, pay family members, which the law allows, and not to have this rigid thing. Local authorities are saving a lot of money by not paying services for families. Families are being sort of isolated, and they're doing all the caring that would have cost local authorities hundreds of thousands of pounds. Yes, the emergency has been expensive for councils, but it's been incredibly expensive for carers, and they have lost huge sums of money in support, and they will need a break at the end. There should be a national holiday for carers at the end, and the accumulated direct payments should be used for that. There's been very few court cases so far, and those are largely about visiting restrictions, where councils or care homes have been sort of insufficiently flexible. So it's about allowing people to wave through windows, or training learning disabled residents in the use of iPads and other things like that, being flexible. What we're seeing in some parts of the country, which is problematical, is that care packages are being cut because it's just physically impossible for the local authority to deliver it. And then local authorities saying, we're not going to reinstate that support without a reassessment. So there's this fear that families will be told that they're not going to have the service they had before the emergency, because they've got to be reassessed. And during the reassessment, the local authority said, well, you've coped, therefore you clearly had more than you needed, so we'll cut it back because you've coped without it. Now, I think that is, if local authorities do adopt that view that they've got to be reassessed, I think there's going to be a lot of litigation. Legally, I think it must be wrong. A need continues until the authority has evidence that it doesn't. And the mere fact that a family hasn't all committed suicide or had nervous breakdowns or divorces doesn't mean that they've coped. They've just had to endure that problem. So the local authority would have to produce evidence to show that the person's condition had improved, or some other material factor had intervened, rather than the mere fact that the family's coped. And also the local authority has got a duty continually to meet the need that has been assessed. So if there's any way of delivering it, if the rules are relaxed, then it must continue to do that. It can't just say, we're not going to resume it until we've had a reassessment. I've only come across that in pockets throughout England and Wales, but I hope it's not happening in your area. Disabled people conflict, I sort of looked at this issue earlier, that this is an issue and there is a need for conflict resolution, sometimes for different, for the care and the disabled person to have a social worker each. The problem with conflict resolution is not that social workers don't have those skills. They have those in abundance, I think. It's just that they have crazy caseloads, so they don't have time to try and diffuse these situations. They've got to carry on trying to do this. And I give an example of the classic example of the elderly person with dementia who won't have anybody look after her, although her daughter needs a break. And so in that case, the local authority convinced the elderly person that somebody's coming in to help the daughter with her housework and the washing. And after a few weeks, of course, the elderly person becomes familiarized with the carer, accepts them, and then the daughter can go out and have a break, and the care assistant can remain to do what she was really employed to do, which was to care for the elderly person. Information sharing, if a disabled person lacks capacity to agree to the sharing of their information, then GPs or social workers can share the information if they think it's in the person's best interest. There's no law that says you can't share personal information. The general principle is you shouldn't do it if the person refuses, but if they haven't got the capacity to consent or to refuse, then it's simply a best interest decision. And the General Medical Council guidance to GPs is that if the person lacks the ability to consent to their file being shared by their family, the doctor should consider that it's reasonable to assume the patient would want those closest to them to be informed of their general condition and prognosis. Now, there we are. I've overrun a bit. Sorry to all of you that's had to listen to that and me droning on, but Pam, what I suggest I do now is to just go through some of the questions I've had, try and do that fairly quickly so that other people can ask questions, and they can put those questions in the chat function to you or to one of your colleagues. Is that right?
That's right. So I do have a couple of questions that have come through. You have covered a number of them in your presentation, so that's good. So yes, if you could kick off and
okay, well, I do apologize for everybody having to sit through this, but it's something I find fascinating and I hope it's been useful. So what I've done is I put these questions up, the ones that were sort of asked to be answered publicly, so I hope that's okay. So some of these are very quick, some of them are not so quick. What rights do carers have regarding flexible working and time off for the caring role? That could take me half an hour to answer at least. So what I want to do is to just say to you, go and look at chapter 15 of the Carers' Rights Guide. That's the one I showed you at the very end, at the beginning, where you can go to my website and download it. Chapter 15's got a section on it. Basically, carers have rights to emergency leave. So if you have emergency, it doesn't have to be an emergency. It could be that somebody's got to go in is told that they've got to go in 3 days' time to hospital or something like that. Then there's the carers have a right, as long as they inform their employer at the earliest opportunity. And normally that would be within 24 hours or whatever. They have a right to emergency leave. Of course, it's unpaid. And that's true also for flexible working under the Children and Families Act 2006. There was the flexible working arrangements brought in, and you can apply to your employer for flexible working, and there's a procedure, and again that's dealt with in chapter 15 of the Carers Guide. And although it's a right to ask, there are quite significant problems if employers refuse. They could be taken to tribunal. So there is a process. Disability Law Service did some research on this and showed that it's not working very well. Yeah, so it's not good. It's not. There are rights, but they could be a lot better, and those are really important rights because carers have to, because work is becoming such a hugely vital thing for families, for all people in families. So if it's okay, whoever asked that question, I'll refer you to that section of the book, and it's dealt with in detail. What rights do carers have to right to stay in the house after the carer for is deceased or moved to a residential care home? Well, if they're deceased, then it all depends on the will. And if there's no will, then it all depends on the intestacy provisions. So that's a really probate issue. But once somebody dies, you look at the will. There is a power to challenge a will under a thing called the Inheritance Provisions of Family and Dependents Act, but that has to be done within 6 months. So if you're a dependent person and you're in the house and the person dies and doesn't leave you any rights, then there is always a possibility to challenge the will. If, however, which is a more common situation, the person moves into a residential care home, but they're not the spouse, then the rights to remain are set out in the statutory guidance annexes. Well, yeah, I'm reassessing this question. Your rights to stay in a residential, in the house, depend upon the owner agreeing to that effectively. But a local authority can't force you out of the home in the following situations. If, and this is to do with whether the value of the house is taken into account for charging purposes. The first thing is if somebody moves into a residential care home on a permanent basis, they can agree I forgot the name of it now. They can agree to a deferred payment scheme so that the house is not is kept during that person's life. If they haven't got, but they don't have to do that if the house is occupied by the resident's partner or former partner. So it's not just spouses, it's partners. So you don't have to be married to the person, and all that's required is a common law relationship. So it would include obviously gay relationships in that context. If you're not a partner or former partner, then the house is ignored if you're a relative, but the relative needs to be either 60 or over or under 18 and liable to be maintained by the resident, or incapacitated, which means that you would be eligible for an incapacity benefit. So there's quite a lot of complexities there, but I don't think I can go into it in any greater detail than that. There will be some Age UK, I'm going to refer in a minute to an Age UK guide. Age UK guide will have that. In my big book on community care law, which you can get from the library, or I know somebody's asked a question, he's clearly got a copy of this. There's a big section on all of that. There's quite a lot of law there. What rights do carers have to be involved in the discharge process of care planning? Well, I've looked at that a bit. In the carer's guide, again, that I've referred to you a couple of times now, there's a chapter on NHS responsibilities and discharge planning. The discharge planning guidance pre-COVID is littered with requirements to consult and negotiate and discuss with carers. This government has recently issued guidance called Hospital Discharge Service Policy and Operating Model, and it's truly awful. Whereas the previous guidance probably mentioned carers' involvement 50 times, this guidance really only mentions it only mentions carers 4 times, and there's a duplication, so in reality it's twice. And it's all about carers being told, no discussion, just being told. Now, I know off the record that there are some very vociferous conversations going on with the Department of Health from carers organisations about how incredibly crass this guidance is. So hopefully it will be remedied. Well, yeah, let's hope. Who should sign a contract with a residential home when the cared for is part self-funded and part social funded? it should be the local authority. I'm not going to go into detail that. I qualified that by saying in almost all cases, but in reality, it should be the local authority. The local authority is always in a better position to negotiate fees than individuals. Self-funders generally pay 30–40% more for the same place as a local authority. If things go wrong, then the local authority can be blamed if its name's on the contract. There's all sorts of reasons why it should be the local authority's name on the contract. There may be reasons when it shouldn't, but I can't think of them. What rights do carers have to a choice of the care home for their loved one when they're not self-funding? Well, clearly the local authority, if they place someone in the care home, is making a decision. Clearly the disabled person, the elderly person, should be the most involved in that. But if they lack the ability to make that, the local authority would have to make a best interest decision. And it clearly would have to involve the carers, those concerned about their welfare or involved in the care. That's under Section 4 of the Mental Capacity Act. So the carers should be fully involved in the decision and provide evidence-based reasons. At the moment, I think that that's going to be different because they've got this strong guidance about discharge. So yesterday I was told that a very close relative of mine, for whom I'm the spokesperson, was being discharged from mental hospital to a care home, and I wasn't discussed with me at all. It was just a fait accompli. But I can't really argue with that because that's what's happening in the emergency. But if that wasn't at this sort of time, I would have been very cross that I hadn't been informed and consulted about choices. What help are carers entitled to from social services when they're completing a financial assessment for the cared for, and what is taken into account? Well, I don't know what the law says support should be given to carers who are filling out a financial assessment form that would normally be completed by the cared for person, but obviously they can't do that. I'm not aware of any guidance on that. What is taken into account for charging purposes? Well, that's just such a complex question. I can't really go into it. They are beyond the scope of this lecture. Age UK has got a good guide on that. It's got one for residential care and one for home care, people that live at home. I don't know if I put that in there. Yeah, paying for home care. It's the biggest book, biggest chapter in my book on community care. I think it's over 100 pages long. So it is complex. I think charging is outrageous. It's a scandal. I think the charging rules are appalling. I think social care should be free at the point of need. It wouldn't be expensive, but at the moment it's causing enormous hardship for many families who are already on benefits, and it's reducing their income. But I can't go into that. As I say, look at probably Age UK has got the best guides on that. Somebody has got it's a long question this was, but effectively it was, is somebody better off funded under the Care Act or NHS Continuing Healthcare Framework? Again, this is a very big chapter in a very big book of mine, and there's a huge amount written on continuing healthcare. There's a curiosity. Section 22 of the Care Act says that when somebody's needs are above a certain level, then all their health and social care needs have to be funded by the NHS. So there's a point at which you go above a certain level, you tip from being funded by the social services to being exclusively funded by the NHS Continuing Healthcare, by the Clinical Commissioning Group in Enfield. And once you've gone above that limit, the limit of social care, it's unlawful for social services to be involved in the funding arrangement. Once you are the responsibility of NHS continuing healthcare, they have exactly the same duties to provide personalised care and support packages as social services. They have exactly the same powers to provide direct payments. So in theory, nothing should change. It would be like you've moved from Enfield to Haringey. In theory, Haringey social services have got the same power as Enfield social services, so in theory, you should get the same sort of service. In practice, there are pros and cons, but in theory, the service should be the same. And you don't really have a choice. I mean, that's the point, is you could, this question was, well, you know, should we try and get, I mean, once you're above the line, legally, you don't have a choice. It's got to be funded by the NHS. And if the NHS and social services have agreed that you're above the line, then there is no choice in it. So you, in a way, there's no need to worry about this issue because it's simply out of your hands. The person that asked to create a discretionary trust fund, which is a very sensible idea if you've got an adult child, one of your children who is adult, lacks the capacity to manage the money and is unlikely to live independently, then that's a very sensible thing for families to do. And MENCAP have a service that is well regarded in that respect in creating these sort of trusts. Sorry, I've got a spelling mistake there. One of the cons, one of the problems about being continuing healthcare funding, and in one sense it's very good because of course it's a free service, but in another is that you can't top up packages under NHS, whereas under social services, provided social services meeting a need that you can top it up, you can't with the NHS. But that's quite a complex issue. And again, you probably have to just go to the library and have a quick skim through chapter 13, paragraph 170. The duty on local authorities to provide a service user or their representative with a breakdown of how their financial contribution is how. Yeah, somebody was suggesting that the local authority was proposing only to do this on request. My understanding is local authorities have got to do it, whether there's a request or not. It may be administratively easier not to do it and just ask for a request, but I understand that the duty is to do it, full stop. I mean, there's a slight problem here. In the sense that if you make a complaint that you haven't been given it, they'll give you it, and then you won't be able to make a complaint because you haven't got a problem, you're not a victim. I suppose there could be a representative complaint made to the Ombudsman about this. But my understanding is the charging rule guidance and regulations say that people should be given a breakdown of their costs. And charging is hugely complicated and, as I've said, appalling. I've been asked about how you calculate the use of the minimum income guarantee. And as I say here, the charging rules set out by, in the legislation for adult care is a disgrace. The minimum income guarantee is the minimum amount you must be left once the charge has been levied. And the charge, and you must also be left with things like disability-related expenditure. It's really complicated. The minimum income guarantee hasn't been uprated for a number of years. So in effect, when social security rates go up, which of course they're not at the moment, that additional money is actually just raked off into social services coffers. It doesn't go to the individual. I think it's outrageous. I think it's arguably discriminatory. Whether one could take a legal case on this, I don't know. When I drafted that note yesterday, I didn't really think so. Now I think maybe there would be. It would be interesting for lawyers to do this. There's been very little litigation on local authority charges. but they're becoming outrageous. They're reducing people on breadline to well below that breadline. And I've got a number of posts on my website about this, and one of them is specifically about the failure to uprate the MIG, the minimum income guarantee. So if you go to my blogs, my website, which is the What's New page, and you scroll down, you'll see a lot of stuff about charging. I have full power of attorney for my relative who I haven't seen for several months in the care home. I want to remove them from the care home and get them to live with me. Is there any law preventing that? Providing the disabled person is not subject to a legal order depriving them of their liberty, and providing they are satisfied that moving them would be in their best interest. I can't think of a specific law that would prevent you doing this. But if you've got a power of attorney, you can't move somebody unless it's a personal welfare attorney. Most lasting power of attorneys are just property and affairs attorneys about finance, so that wouldn't give you any power to move somebody. And even if you have a personal welfare LPA, lasting power of attorney, you've still got to act in the person's best interest. That's Section 4 of the Mental Capacity Act. So you'd still have to consult with the key players. And, you know, generally one would urge caution in a case like that. But there are cases where families have pulled people out, and it's been a good thing. Yeah, this is a question of, which I probably touched on, is that during COVID, my son hasn't been able to attend his normal service. Can I use his direct payment to buy another service to keep him occupied? Well, the answer is direct payments have to be used to purchase service that were listed as assessed needs by your son. But I've really stressed that the COVID guidance goes on and on about flexibility. And so really there's probably a need to take this up with the local authority and say, you've taken legal advice from Professor Clements and he says it's okay, something like that. But I've looked at that earlier. My daughter's social worker is insisting that she cannot change what was on her support plan. I use her direct payment to buy gym equipment and arts equipment during COVID. Are they allowed to insist on this? They've got to be flexible. If this PowerPoint you'll be getting, you need to go back, refer to the ethical guidance under COVID, which stresses acting reasonably, person-centered, being flexible. What the local authority is saying is we're going to try and save money because you won't allow you to use a direct payment for that. But clearly, an alternative use would be imaginative. So I think that there will be a lot of pressure on the local authority to explain simply why they won't do that. Simply saying we can't because it wasn't assessed is being rigid. And the one thing we're being told is that they must not be rigid. This is somebody who can't really cope anymore, so she's intending to basically give the keys to her house to the local authority and walk away for her sanity. And is there any comeback? And what will happen to her husband? Hugely, incredibly sad question. Well, there's no duty on adults to care for other adults or spouses. We don't have to care for them. And as I've said, the local authority can't assume that you are willing to provide care. Providing that he's not put at significant danger, I suppose that the local authority has given adequate notice. I can't see that there's any law that's broken there. Local authorities would have to provide support for the husband if possible, and then to enable you to stay in the relationship. But of course, if you do that, then the local authority will say, well, we'll decide what happens. They should still take into account your wishes and feelings and your views, but you can imagine local authorities becoming very censorious in those situations, which will clearly be inappropriate. So wasn't quite clear what this question was asking. As a carer, do I need to prove that I have needs, and due to changes in my circumstances, can I make social services provide the same level of care that I have been giving? So I think what somebody was saying is that they're providing care for a cared for person. They're no longer able to do this, so they want to ensure that what they were doing will now be done by the local authority. If you're no longer able to provide care for a disabled person, social services will have to assess what support they need and provide this. So you can't guarantee that the local authority will provide the same level of support. They will go through the eligibility criteria. I think if they do provide less support, they would have to give evidence as to why they think less is appropriate, and you could then complain about that. Yeah, that's what I was saying. I live in private rent property. What is to adapt the property so it meets the needs of the cared person? Well, if you live in somebody else's property, then you've got to get their permission to change it. It's their property. You need to obtain consent. The Equality Act says that landlords have not ever come across the property owners shouldn't discriminate against disabled people. So if you want to make a reasonable adjustments and they're refusing to allow you to adapt it, they would have to give reasons why they're refusing. So it depends, I suppose, on the nature of the adaptations, but there would have to be a conversation with the property owner, and the property owner, if they refuse, would have to explain why. I'm planning to quit my job. What support can I get? I'm not a social security expert, so I can't answer this question. In general, UK law makes very little provision for carers who are experiencing hardship. The carers' allowance is a disgrace. We don't provide social welfare support. We provide laws that give you right to assessment, and we give you a right to token service, in my opinion. If you really want to address the needs of carers, you would have really good rights to work, not flexible working, but you lose the money. We would have really powerful rights-based legislation concerning the work, people's right to work, and we would have really significant compensatory payments, so that instead of getting a fairly tokenistic carers allowance, it would be a substantial sum of money that would enable carers to continue caring without experiencing ill health and poverty. But at the moment, I think that if the support you will get is likely to be very little. Cool.
Thank you, Luke. That's much appreciated. There are a couple of questions that have come through on the chat, but okay. I actually just wanted to follow up on that last question. We do have a benefits advisor, Marion, who's going to be on our panel later on, and we'll be able to take all of the questions today. Certainly people can ask some of those questions at one-to-one appointments or one-to-one conversations with Marion. That's not a problem. And also we do have links with the local Enfield Citizens Advice Bureau, and we can make sure that they can get access to a particular diary through a local organisation, so that they don't have to stand in line waiting for the appointment at the crack of dawn. They'll be able to do that. So really appreciate that. So a couple of the questions that came through, Luke, was just quickly try to skim this. A carer is an appointee for his brother's DWP benefits, and but mental health services are referring him to adult social care to take over managing his brother's finances. And the question is, what grounds do they have to do this without involving the carer as the appointee? He doesn't have lasting power of attorney.
No.
But, you know, are there any grounds for them to do that?
Well, it's interesting issue. So if your only income, if you're a disabled person, your only income is Social Security benefits, then you don't have to get a lasting power of attorney, as this person says, as you say. They just become the appointee. Now, the appointee is just an administrative function done by the Department of Work and Pensions. And the Department of Work and Pensions, it appears, could just decide to make the local authority the appointee. I think there's a potential European Court of Human Rights case under this because there is no right to a fair hearing in relation to that, which is an Article 6 case. So I think the Department of Work and Pensions would have to give evidence as to why that change is being done. I think they can make a complaint, but there is no really, it's a sort of, there's no real rules that regulate that. And the UK, when it ratified the UN Convention on the Rights of Persons with Disabilities, accepted that the appointee system did conflict with the convention, and I think it conflicts with the European Convention. Now, I have written about this, so I'm trying to think of where the hell I've written about it. Anyway, there is a legal argument under that. And I think the best person to answer this question, there's a barrister called Oliver Lewis. He's a colleague of mine, but he works at Doughty Street Chambers. And all you need to do is to Google Oliver Lewis and pose that question to him. He won't like me for this, but I know that he has taken a court case on it.
Right.
So he'll probably give you a very brief answer, but I know that he's taken a court case on this.
Okay, so Doughty, D-O-U-A, I'll put that in the chat.
D-O-U-G-H-T-Y, yeah. It's the best practice. Keir Starmer was a barrister there. It's a good practice.
Thank you. Okay, so another question that's come in is, let me just bring it back. So the carer's father's recently been admitted to a care home and tested positive for COVID-19. The home was closed to all visitors, and since then, however, her father has had 2 tests, both of which have tested negative. The carer is concerned as to why she, her mother and sister are still unable to visit her father despite the negative test. She doesn't know whether the home are keeping them away because of government rules or because of their own.
I mean, it's just a really difficult question. The court case is under that. I mean, it could be both. They both got to be flexible, but they, you know, the wiggle room at the moment with the courts are going to give a lot of leeway to homes and the local authority over these things. All that the questioner can ask for is that the home give her reasons, and those reasons must be rational. And if she thinks there is a way for them to be flexible without compromising the security of the other residents and the staff, they should consider it. But at the moment, it's only when you get an absolute refusal without any rational reasons that the court is, or the ombudsman will be willing to get involved.
Another question that was asked by a carer is that a nursing home that's part of a chain of different homes appears to have different rules of visiting. So one home will say 2 visitors a week, but another home owned by under the same ownership is saying 1 visit.
Yeah, I mean, I think again, there could be very rational reasons for that, because the layout of the building could be different, the corridors could be narrower, the spaces could be different, the ventilation system could be different. So I think there are rational reasons for different places having different rules, but they need to tell you what those rational reasons are. They can't just say, well, we have different rules and not enter into a rational discussion.
All right. Sorry, quite a few conversations in the chat, so just one moment. You did cover some of this, Luke, in your question about CHC and continuing healthcare and the Care Act. And I think the issues were really more about the rights to respite care plans and how to challenge reductions in care without the Care Act to back them up.
Yeah, I mean, continuing healthcare I mean, in theory, everything should be exactly the same, whether you're funded under continuing care or social care, except you don't have to pay any fees or charges. In practice, the NHS, and this is sort of almost stereotyping it, but after 40 years of doing this work, it strikes me that the NHS is much more hierarchical, rigid, less willing to take risks, less willing to be less good at being person-centered. And historically, the NHS has said, we don't do respite care. Respite care is a carer's service and carers are responsibility of social services. Well, that's nonsense, because respite care is normally a service given to disabled people. Somebody sits with the disabled person, somebody provides a service to the disabled person so the carer can get a break. So the service the carer gets is a break. But respite care is a service given to disabled people. So respite care is core business for the NHS. The new continuing care framework, 2018, is much better on the obligations of the NHS than previous ones. And I wonder sometimes whether the NHS has actually read the new guidance. The new guidance says quite sort of dramatically that the NHS has a duty to assess carers. Now, I've been involved with Carers UK and trying to change the law on create some obligations on the NHS for carers for 20 years, and we haven't succeeded. And now we've got a bit of guidance that says there's a duty on the NHS to assess carers in continuing healthcare contexts. So I think it's a question probably of the questionnaire educating the NHS about their obligations, and they may well be dealing with frontline staff who say we don't do respite care, and the answer is, I'm sorry, Ducky, you do, basically.
And certainly, I think that our staff would be nodding here, because we firmly believe it is about making sure carers have the information.
Yeah.
And then our advocacy skills training will equip them with the skills to assert those rights. You know, if they come across as knowledgeable, sadly, in this world, it is about the person who is firm in what they understand and firm in getting that message across. And then people start listening, oh, this is a person who knows what they're talking about, so they'll start paying attention. And that's really what carers need to do.
Yes, and that's why it always comes back to support, and you can give them that, and you can, you know, and it's the credentialism. Enfield Care Centre says this, you know, it sounds so much better than saying, well, I've read that, you know, yeah.
Lovely. Thank you very much, Luke. I think that's all of the questions that have come through in the chat. So what we're going to do now is move swiftly into the Meet the Team. So this is where, and Luke is still around till about, we've got him for another 15 minutes or so.
Yeah, sure.
Is that right?
What's the time now? Yeah, another 13 minutes.
Okay. So our team members are shortly going to be spotlighted. And this is where you have an opportunity, really, carers in the audience, to ask any questions if you like. We have had some pre-submitted questions, which I've got here. So we'll start off with those. Members of our team then are, well done. Okay, so we have Danny Newland, Carers Advice and Support, Carla, Young Carers, Matt, Young Carers Support, Kevin from Transition Advocacy. Hopefully we can get Kevin on. Marion from Benefits, Alex, who's our Home Care Manager, Mark, Hospital and GP Support, Fiona for Operational and also Care Home Support questions, and Health and Wellbeing advice from Karina. So first question that we've got, actually still might be might be for you, Luke, but we've had a few experiences of social services wishing to arrange to advocate for a young person whose parents do have an LPA or even full deputyship, for those of that capacity, and yet the authority's still gone down this route, even though there are no questions or issues such as safeguarding with these carers. So what do you think about that? Carers are concerned really that it's just brought up in order to delay the progress over key issues such as support packages, direct payments, accommodation.
I'm happy to start the ball rolling on this one.
Sure.
Yeah. The advocacy rights under so this is an adult child, presumably.
Yeah, it could be a young person in transition age, actually.
Yeah. I mean, if there's an LPA, it's probably an adult. Yeah, I mean, the rules on advocacy under the CARE Act are not predicated on whether there's an LPA, but normally you only have a right, the local authority could use its power to have an advocate. But the right to an advocate is only if there is nobody there to speak on your behalf. And I think that what the family should do is to say, this doesn't come within the duty under the CARE Act. Can you just call a spade and just tell me, or call a shovel, or whatever it is, just tell me what it is that has prompted you, who presumably doesn't go around appointing advocates in every situation, why you want an advocate here. And I imagine they want an advocate here because they're not terribly pleased with what the parents are saying. So I think the local authority's got to give reasons why it is trying to muscle in, because the right to family life continues. So it's a significant thing. There could be very good reasons. They think they're being overprotective. They think they're being over-controlling, you know, but I think the local authority's just got to just tell me exactly what my problem is.
All right. Thank you very much, Luke. And the next question that's been submitted is actually about home care services. So the question is, now that we've merged with Crossroads, how much does it actually cost for home care services? And can you provide services for people with mental health issues as well as people with physical disabilities?
Yes, we apply a flat rate. So Monday to Friday, we charge £17.50 per hour. And over the weekend, Saturdays and Sundays, we charge £19.50 per hour. And definitely we provide services, you know, for people with mental health. It can be people living with anxiety, depression, bipolar disorder, people living with dementia, Alzheimer's disease, or challenging behaviors. And of course, we provide services to people with the physical disabilities. They might recover from a heart attack or a stroke, or they might fight against a cancer, or sometimes they might be, you know, wheelchair bound or bed bound. We look after young adults and children under 16 with learning disabilities, cerebral palsy, autism, global developmental delay, and things like that. So our aim is to make sure that we provide both emotional and practical support to our clients, and that we can meet, you know, their needs, and they can achieve their outcomes.
Thank you, Alex. Thanks very much for that. I realised that I've neglected to thank Luke for the presentation. I think really informative, and I just wanted to say that we will be able to send copies of your presentation around to all of the attendees. So don't worry, you will have all of that wealth of information, and also with the links to the site and for the book. So I know you're not going yet, but I just wanted to thank you before I missed that. Lovely. So our next question then is, I know that there are many carers who are keen to resume some kind of face-to-face activity, and some do feel a bit cut off. And we understand that the online activities isn't for everybody. But when do we think that ECC will be able to open up again properly? So I'm going to invite Fiona to answer that question, please.
Okay, so obviously we Obviously, we are keen to get our face-to-face services back into action as well. We're really missing having the carers in the centre. We were, ironically enough, starting to look at that and talk about it at the end of July, August. Pam and I were starting to think about having some socially distant support groups. And of course, the second lockdown, the numbers started rising and the second lockdown came into play. It is a dialogue that we're having constantly. We're monitoring the situation nationally, following the government guidelines. We are also talking to carers, because obviously we are running a lot of our services digitally, and we are talking to the carers that are attending the groups and asking them what their thoughts are. So I mean, I ran the bereavement group last month and I asked them about how they'd feel about having a socially distanced event, for example, in the car park, and they said no, they wouldn't feel happy doing it. So it's a combination of obviously following national guidelines. We want to get things up and running as quickly as we can, obviously, doing the right risk assessments, keeping the staff safe, but also you have to remember that we're working with carers who are very vulnerable and the people they care for are really vulnerable. So we need to be really careful and really mindful of the situations we're putting carers in. One of the things we have done is set up a digital library. We're aware that there's a lot of social isolation. There's been a lot of dialogue with the council about reaching out to people that have become very isolated and the knock-on effect to their mental health because of that. We have set up a digital library at the Carers Centre. We are lending out devices to people that are already set up with the Zoom all ready for them to go. We've got our wonderful volunteer Nicola, who's available to remotely access the devices and help carers to get online if they're not that IT confident. So we're doing everything that we can, and we totally understand and appreciate that some people are not comfortable or are able to access online services. But as Tim mentioned earlier, some people are feeding back that they're able to access services that maybe they weren't able to before because they can't leave the cared for, or they maybe have a mobility problem themselves. So obviously moving forward, you know, as soon as we can, we'll start to resume face-to-face. There may be a combination of face-to-face and digital services going forward, but it is something that we're constantly monitoring as a management team and as a board, and you know, we're doing our best to deliver and get to as many people as we can. Thank you.
Thanks, Fee. Thanks very much. Okay, so I've got a question here for Karina and Mark, really, because it's a common question and it is of interest to carers, is how to access out-of-hours help when someone's silence. Sorry, is there a lot of feedback from me?
I can't hear any feedback.
So it's how to get that out of hours help and to avoid really taking them to A&E for non-emergency conditions, especially during the pandemic.
Okay, if I take the first part, then I'll hand over to Karina. I mean, firstly, I would reiterate that if it is an emergency and people think it's something that is quite serious, then never hesitate in ringing 999. You should, I know that's not within the question that was asked, but we always like to make sure people are aware of that. Don't be scared of ringing the emergency services. Getting a non-emergency appointment was quite difficult even before COVID. And a lot of things have now moved online with GP surgeries, for example, and people are finding that quite difficult. And I know within the CCG that they're looking at those people, of course carers, that are digitally excluded from being able to access their GP surgeries or other places. But as a good alternative, there's no harm in ringing 111. In fact, 111 will triage your complaint or your concerns. They might take a little time to get back to you, but in my experience, in my personal experience, quite recently, they were excellent. But they can triage the concerns that you report to them and then signpost you to the right service, even making an appointment at the local GP service. Local GP surgery. So that's what I would say, call 111, and I'll hand over to my colleague over that way.
Thank you. Hello, hi, I'm Karina, and my background is in clinical nursing. I'm a registered nurse, and I deliver the healthcare training for the carers at Enfield Care Centre. The training has been running now for 3 years, and it covers basic clinical skills, but it is delivered in quite a comprehensive format, but it's easily accessible to carers. And we make sure that it is language is there's not too much medical jargon in the course content, although it is comprehensive. And I would encourage all the carers to attend the training that we deliver for the clinical skills, because it is mainly aimed at preventing hospital admissions. And the aim is to keep people, to keep the cared for in their own homes as much as possible, because that is their best environment. So the topics like Fiona mentioned and Mark mentioned are covered are several clinical areas like medication management, skin integrity and tissue integrity, which is very vital elements, as well as guiding carers through how to navigate the NHS community services. So please, I look forward to seeing as many carers as possible on our course. So yeah, that's all from me. Thank you.
Thanks, Karina. Thanks, Mark. Okay, so the next question is aimed at Carla, actually, for young carers. Why don't we provide services for activities for children with disabilities, as well as for their siblings, as well as for young carers and families? Oh, there's been a musical chairs. Did you hear that question, Carla? Okay, let's unmute you, sorry.
Sorry, I needed to wait for someone to let me unmute. Apologies, Fiona and I are in the same room, and it doesn't work if we have the speaker and mic on at the same time. Yeah, so we totally understand that young carers have a special bond with the people that they care for, and they often, I know they'd love to have their siblings come with them to some of the activities, but the fact is that they really need to have a break from some of their caring responsibilities at home, and having a break from this role means that they can then return to their caring role fully refreshed. And the other thing is, if we had an integrated service, so we had the siblings there with the young carers as well, the young carers would continue their caring role, and so they wouldn't really be getting a break themselves.
Thanks very much, Carla. I have a question now for Marion, our benefits advisor. We've still got, yes, we have got Marion. The question is, can I claim carers allowance, and will it affect my benefits or my cared for person's benefits?
I can't. Right, yes, hello, I'm the benefits advisor. Yes, carers allowance can impact on your benefits and the person you care for benefits, and I always suggest that you do a benefit check before applying for carers allowance, especially now with the new universal credit. If you may not be actually getting carers allowance, but you may be getting a carers element in your universal credit, which will basically affect the other person's benefit the same as though you were receiving carers allowance. So yes, please do a benefit check for yourself and the person you care for before applying for carers allowance.
Lovely, thanks, Marion. Marion, did you also want to add anything to the question I think that Luke touched on earlier? Was about
yes,
person planning to quit their job and look after their loved one. What's available for them?
Yes, you can apply. You can apply for, if you're on a means tested benefit, a mortgage interest loan from the DWP, but it only pays some of the interest on your existing mortgage, and there are a lot of a lot of rules about who can get it and who can't get it, and it is secured on your home. So at the end, either when you sell sell your property, if you die, or if you transfer the property into someone else's name, it will have to be paid back at that point. So it's really, you're just taking another loan to help towards the interest that you're already paying, and it may not cover the whole of your interest, especially if you've got a high interest mortgage.
Okay, thanks, Marion. Thank you for that. Okay, I think this is the last question that I have actually, aimed at the carers advice and support team. Why don't the council allow people from the same households to provide respite? Wouldn't using people from the same household help to reduce the spread of the virus? And I'm not sure that the council don't allow, but if we could unmute Danny and Matt, and they could respond to these questions, please.
I'm a little bit confused as to about the question about people from the same household providing respite, because normally that's the first option. If a family carer is providing care for, let's say, for instance, their elderly parent who has dementia or something like that, and if that family carer, son, daughter, whoever, needs a break, normally the first question is there somebody else from the family who could step in, take over your caring, or to enable you to have a break? Everything should be assessed, obviously, by social services in their assessment of the person's needs. If the question is about, if the question was really about funding and stuff like that, about somebody from the same household providing respite, about diet payments and things like that, then there's issues about financial fraud or something like that, or questions. But I'm a bit confused about why somebody from the same household would not be allowed to provide respite. Obviously, there shouldn't be an assumption. Perhaps that's the question, that there should not be assumption that somebody else in the family can provide, take over and provide respite. And if there is a need for the carer to have a break, then social services should assess for that need and be able to provide that need. I don't know if Danny wants to say anything clearer than I've been able to about it.
I think it comes down to you know, the logic and the practicalities of it. So I think that perhaps this question is more about being paid via direct payment for care, because, you know, respite does come down. We often get carers where the person that's being cared for goes to stay with another family member, and no one really interferes with that. Social services is not involved. It's usually the informal arrangement. But to accept a payment to be a paid worker does involve a number of legalities. So if you're trying to get a direct payment, you know, it has to be audited, so the money has to be shown. If you're employing someone, is it on a contractual basis? If you're an employer, are you going to pay their pension contributions? Are you going to pay, you know, the annual leave, legal obligations that you have for them? You know, are you? And these are the things, really. So it isn't impossible for a family member to be paid provide respite if they know how to use the equipment. There's no health and safety. If I asked for a care worker to come into my home, I would expect them to have reasonable knowledge of conditions, be MVQ or vocationally trained to a standard, have health and safety training, you know, this. And I guess that if we're asking a family member to provide paid equivalent services, we expect them to be at some kind of standard of care, even though we know that they're probably experts in care in their own right. But the simple fact is, if you've got a piece of equipment and the council are paying you to provide care and you don't know how to use that equipment, that's a health and safety breach and possibly an employment breach. And I think that that's it. So, you know, if you run someone home from a carers meeting, for example, and your friends, that's great. If I was to do it and I worked at the centre, I'd have insurance issues. I could have allegations of something inappropriate said in the car. You know, this is the difference between practicalities of paying someone to do something and then just doing it, I'm afraid. And I think that's probably the best response I can give.
Also, I'd just like to add that a carer who opts to be to receive a payment for delivering the care would then not be able to also request a carer's assessment to discuss the impact of caring on them, as they've chosen to do an element of it as a paid job. So the difference would have to be measured, I think, in that way. So I think, you know, that's something else that carers need to bear in mind. Okay, so I just wanted to check with the team whether there were any other questions that had been submitted to them directly that they wanted to take care of now. Okay, I think that's a no then. And I'm not seeing anything more. Oh, Mark is still, no, Mark doesn't, here you are here, okay. Mark, did you want to say about Pharmacies, sorry, you sent me a note about pharmacies.
Yeah, sorry, when I gave my answer to the question that was asked about sort of non-emergency conditions, I should have mentioned pharmacies right at the beginning, because often the pharmacy is a good option if you've got a good pharmacy with a good chemist. And it is a minor condition, you know, sore throat, cold, rashes, that type of thing. You know, there's no harm in going to your pharmacy. So that's another option you could utilise. That was it, really.
Lovely, thank you. So I'd just like to thank everyone for coming, for their time. I really hope that you found it beneficial. I'd like to say a special thank you once again to our digital volunteer, Nicola, and also to Caroline, our senior administrator. They've been an absolute force behind all of the arrangements for today's events. I would like to encourage you, please, to respond to the short, very, very short feedback, the short online poll and the survey that's about to come through very shortly. And if you could feedback on the event, I really hope that you found it useful. But if you could give us your feedback, that will also help us to improve what we do and how we do it. Thank you very much.